When markets prioritize themselves over the common, and when social welfare protections evaporate while the gulf widens between the moneyed class and the rest of us, when they attack our classrooms because they are sources of knowledge that can inspire social transformation, then rightly we should all worry about the much vaunted rule of law.
Good evening. Good evening to all, and welcome to the Lowell Humanities Series. My name is Megan Sweeney. I am a professor of the practice in the theology department, and I serve as director of the Pulse Program for Service Learning. Tonight, I am delighted to introduce the Honorable Margaret Burnham, University Distinguished Professor of Law at Northeastern University, where she is also the faculty co-director of the Center for Law, Equity, and Race, as well as the founder and director of the Civil Rights and Restorative Justice Project, CRRJ, which investigates racial violence in the Jim Crow era and other historical failures of the criminal justice system. CRRJ serves as a resource for scholars, policymakers, and organizers involved in various initiatives seeking justice for these crimes. Professor Burnham began her career at the NAACP Legal Defense and Educational Fund. In the 1970s, she represented civil rights and political activists. In 1977, she became the first African-American woman to serve the Massachusetts judiciary when she joined the Boston Municipal Court bench as an associate justice. In 1982, she became partner in a Boston civil rights firm with international human rights practice. In 1993, South African President Nelson Mandela appointed Professor Burnham to serve on an International Human Rights Commission to investigate alleged human rights violations within the African National Congress. This commission was a precursor to the Truth and Reconciliation Commission, which President Mandela authorized and Archbishop Desmond Tutu chaired. In 2021, President Joe Biden nominated Professor Burnham to serve as a member of the Civil Rights Cold Case Records Review Board, and the U.S. Senate confirmed her appointment in 2022. This board is charged with reviewing the records of civil rights era cold criminal cases of murders and other racially motivated violence that occurred between 1940 and 1979. A recipient of numerous awards and grants for her dedication to exploring history, illuminating truth, and confronting injustice in order to protect civil and human rights locally, nationally, and internationally, Professor Burnham's 2022 book, By Hands Now Known, Jim Crow's Legal Executioners, has received numerous nominations, awards, and accolades. By Hands Now Known is a historical project that shows the importance of the deeply human and caring, slow and detailed archival and oral history work to retrieve lost, hidden, or purposefully attempted to be erased stories of victims of racial killings, the impacts on their families and communities, and the complicity of local, state, and federal governments in these murders. By Hands Now Known is also a project for today, attuning readers' minds and hearts to ongoing racialized contempt towards Black people in the United States, drawing attention to the ways in which laws, policies, and practices continue to reinforce Jim Crow hierarchies. And By Hands Now Known is a forward-looking project whose emphasis on the failures of due process, upholding civil rights and the justice system, as well as practices of resistance of the past, can help readers to see and imagine creative responses to meeting the current moment to address pressing social, political, and legal challenges for America's future. We are extraordinarily fortunate, blessed to have Professor Burnham with us this evening. Please join me in welcoming the Honorable Margaret Burnham.
Thank you so very much. Thank you, Professor Sweeney, and thank you, Professor Sellers Garcia, for this kind invitation to participate in this historic and so well-established humanities, Lowell Humanities series. Thank you to the Gerson family members for supporting this, and for all of you who seem to be a faithful attendants for this series and have supported it over many years. It's really a pleasure to be here. So I want to start with some remarks and then share some images with you. This past January, I represented a man named Smith in an unusual proceeding in Dallas, Texas. Edward Smith is 72 years old, and he lost his father in 1956 when he was 2 years old. He lost his father to the electric chair in Huntsville, Texas. Chair is called Old Sparky by some people, although I doubt that that's what the men who lost their lives called it. Tommy Lee Walker, Smith's father, was one of 361 men killed by Old Sparky on the orders of the state of Texas. Tommy Lee Walker was 19 years old when, in 1954, just 5 weeks after 5 weeks before the Supreme Court handed down its decision in Brown versus Board of Education, he was put on trial for murdering a young white woman in Dallas. Black people lined the streets by the hundreds to witness the proceedings. At his funeral in 1956, thousands of Texans, Black Dallasites, and those from across the state came again to bear witness, to witness the tragic and brutal death of a young man. These people came because they knew then what Dallas County public officials, elected officials, would acknowledge in January of 2026, 70 years after the execution, that Tommy Lee Walker had not killed anyone. 9 witnesses, Walker's friends, families, and neighbors, had sworn before a jury of 12 white men in 1954 that this young man was at his girlfriend's home at the time the murder took place, that he sat by her side, they had testified, until in the early morning hours, she went to the hospital to birth his family, my client, Edward Smith. And yet, based on evidence that we now know was manufactured and false, a trial jury and then appellate panels, both federal and state, and finally clemency boards sent Tommy Lee Walker to the chair. He was framed by the state of Texas. These were the facts under review a few months ago when Dallas County Commissioner's Court declared unanimously, after a days-long hearing and on the recommendation of the Dallas County District Attorney, that Tommy Lee Walker, and I quote here, is and was innocent of the crime for which the state had killed him. Now, if you're asking me why we should, in 2026, living as we do in a world of political chaos, care about a 1956 execution, that's fair enough. You wouldn't be out of line. Why, in this moment of increasingly lethal collisions and battlegrounds that are defining our lives, a moment furthering faster than ever, it seems, precarity, insecurity, and vulnerability, a moment of ever more brutal forms of violence, violence hearkening both to an ancient past and portending a horrific future. Why, as we sit here in the midst of this apocalypse of a technocratic, authoritarian world, everywhere where we face specters of destruction, why then should we look back 70 years? So I want to speak to that question of why we're taking this case up now. And moreover, I'd like to speak to what relief is now called for the survivors, not just Tommy Walker's family, but for those hundreds of people who insisted on his innocence back in the 1950s. What movements, what policies, what practices should we activate to secure justice, the justice that these constituencies deserve and have so long waited for? So, first of all, the Walker case stands at the crossroad of two distinct platforms in the field of reparative justice. Through my work with the Civil Rights and Restorative Justice Project, I have had a hand in both of these areas. First of all, in the late 20th century, a group of advocates and social justice activists from around the country turned their attention to the unfinished business of Jim Crow and civil rights justice. And they identified incidents across the country, both federal and state courts, where our court system had failed men and women, largely Black, but also other people of color, people who were killed on account of their race. The cases were well known: the Birmingham 4, the Mississippi 3, the Medgar Evers case, the Emmett Till case. These were all widely publicized. But what we found was that there were hundreds of incidents where the victims were not well known nor their cases highly visible. Black women bombed to death in their bedrooms, killed by police officers and prison guards. Black men coming home from World War II with a bit too much cocky in them, killed for protecting their families, or for getting drunk on a Saturday night, or for asking to be paid for their labor. When my research partners and I began to unearth these forgotten cases, typically we'd find a family for whom the atrocity happened as they saw it just yesterday. And thus we perceive that properly to grasp the legacy of what seemed all too obvious to the most casual student of Jim Crow, that Jim Crow was extravagantly violent, that thousands of people were killed, that the violence blew a fiery hole through families and communities. We all know that or have some sense of that. But in order fully to map this landscape, we needed new paradigms, redesigned analytical tools, new vocabularies and discourses. We needed to both atomize and summarize the material so as to render it fully visible. And thus we with others built a broad community, both within the academy, adjacent to it, and entirely at a remove from it, to collect the evidence, to explore it, to teach from it, to help the communities affected by it take it on board, and to contemporize it and to report out. The Burnham Nobles Digital Archive at my university, Northeastern, which houses 1,000 cases, is a result of that effort. So too is the work I do on our federal Civil Rights Cold Case Records Review Board. Now, at the same time as these cold case initiatives were taking place in the early 1990s, my colleagues at the Innocence Project were using new forensic tools, particularly DNA, to uncover hundreds of cases of wrongful convictions. These cases didn't date back quite as far as we had gone, in part because the DNA didn't survive. Rather, the first conviction vacated as a result of DNA was that of a man sentenced in the 1970s. The exonerations started with a number of DNA cases from 1989. And then in 1992, two New York law teachers and practitioners launched the Innocence Project, which many of you perhaps have heard about. To date, the Registry of Exonerations reports that 3,000 793 people have had their wrongful convictions overturned after spending a combined total of 35,000 years in American prisons. Of these, about 200 exonerees were on death row when their convictions were vacated. And unsurprisingly, given the ascendancy and shaping force of mass incarceration, these 3,793 cases closely align with racialized prosecutorial practices. The registry reports that 53% of the total exonerees in its database are Black, 53%. And the Innocence Project reports that nearly 60% of the people that it has helped to free or exonerated are Black. Of the 200 death row exonerees, 50% of them have been African American. Now, these revelations that essentially the system is replete with erroneous convictions set off a virtual firestorm in criminal justice circles, coming as they did at a time when public awareness of mass incarceration was quite high. Many prosecutors established what they call conviction integrity units, as did the prosecutor's office in Dallas that ultimately led to the exoneration, posthumous exoneration of Tommy Lee Walker. And innocence projects have proliferated across our country. The research industry has launched numerous studies to figure out how so many innocent people ended up with their lives ruined by wrongful convictions. That research is now quite voluminous, and it identifies, bear with me here, 7 primary causes of wrongdoing on the part of prosecutors and their investigators that lead to wrongful convictions. Mistaken identifications, false confessions, tunnel vision, or the cognitive bias that blinds investigators when they get fixated on one version of a crime or on one alleged perpetrator. Informant testimony, imperfect forensic science, prosecutorial misconduct, and inadequate representation. Manifestly, although not reflected in the research or not commonly acknowledged by the research, race compounds the error-provoking effects of all of these causes of wrongful conviction. Let's look at the Tommy Lee Walker case. He was identified by 2 white witnesses from a distance in a flash 4 months before his actual arrest. Those witnesses were on the lookout for a so-called Negro rapist. His conviction was obtained by the captain of the Dallas County Homicide Unit, who had been a former KKK member. He was tried by a ruthless and effective prosecutor, a man by the name of Henry Wade, of Roe versus Wade fame. Henry Wade told Tommy Lee Walker's jury that he, Wade, would execute Walker himself if he could. Prosecutorial misconduct. So that all speaks to this, one of the several reasons why Walker's case calls out to us today. As I suggested, these are 2 sides of one coin. The state's intentional refusal to address lethal historical racial violence, the failure to investigate, intervene, prosecute, or prevent those crimes, and then also combine that with the criminal legal system's brutally high error rate, which fell with particular lethality on Black men and women. We now know that thousands of accused men and women from the 1970s on have been dispositively proven to have been wrongfully convicted. And knowing that as we do, what are we to do about those men and women who were sent to death and for whom DNA may not currently be available? Where these are cases in which there were no Black lawyers, sometimes no lawyers at all, no Black jurors, Black spectators, but thrown to the side of the courtroom or in the balcony. These Walker look-alike cases can hardly be put to the side. Rather, they remain at the center of the ongoing work to map the extravagant damage and its after effects of our criminal justice system. Now, there's a second reason to attend to cases like that of Tommy Lee Walker, and that is that the case calls on us to reckon with the afterlife of racial terror deaths. These cases challenge the logics of closure, of collective forgetting, of organized erasure, postures which currently, but probably always, are in fashion in our country. The cases challenge the myths that are reflected in the twin claims that we are in a post-racial America on the one hand, and the claim on the other that somewhere out there waiting is a splendid white American past, protected by impermeable borders to which, but for immigrants and people who define themselves as on the left, some call them terrorists, but for those people, we could all return to that past. The roots of these rhetorics, the yearning for an unbesmirched beginning and a happy ending to the American story, they run deep, deep in our culture and deep in our law. They throw a shroud of equal justice over the courtrooms where Tommy Lee Walker and others like him met their fate. And they also march boldly into Supreme Court opinions of yesterday as well as today. And they illuminate the fundamental embarrassment that the U.S. Constitution itself is both a source and justification for racialized legality. Indeed, whether as colorblindness, post-racialism, or misremembrance, these efforts to reposition Black subordination to a distant, superseded, sealed-off past have been with us since the end of the Civil War. Consider, for example, the famous dissent of Supreme Court Justice Harlan in 1896 in Plessy versus Ferguson, where the term colorblind first entered the discourse. Justice Harlan wrote, "Our Constitution is colorblind and neither knows nor tolerates classes among citizens." That's a sentence that we can find emblazoned across a century and a half of Supreme Court 14th Amendment jurisprudence. But Justice Harlan also wrote in that same dissent that, quote, "the white race deems itself to be the dominant race in this country. And so it is in prestige, in achievements, in education, in wealth, and in power," close quote. It was, in short, Harlan's view that it would be possible to achieve legal equality while maintaining white supremacy. And it was this colorblind but nevertheless racist theory that defined the courtroom. Consider as well Justice Scalia's 2000 paean to American equality. He said here, in a case about voting rights in the states of the former Confederacy, a challenge to the Voting Rights Act, I quote, "To pursue racial entitlement is to reinforce and preserve for future mischief the way of thinking that produced race slavery, race privilege, and race hatred. In the eyes of government," Justice Scalia wrote, We are all just one race here. It is American. Saying so is essentially saying, I don't see race. But saying I don't see race allows white people to look beyond race, to embrace post-racialism, which is to assert that race, while it might have produced slavery and race hatred, is no longer a structuring principle in inequality. I have a third example here, and that's the Supreme Court's 2023 affirmative action decision in Students for Fair Admission versus Harvard. It was Justice Thomas there who wrote, and I quote, "I hold out enduring hope that this country will live up to its principles so clearly enunciated in the Declaration of Independence and the Constitution, that all men are created equal, are equal citizens, and must be treated equally before the law," close quote. Neither Justice Harlan, nor Justice Scalia, nor Justice Thomas were the originators of the proposition that equal protection of the law could live side by side with white supremacy. Rather, each was reiterating, whether they appreciated it or not, the historic ongoing contest captured in the very Constitution that they extolled over the scope and nature of equality in this democracy. Their statements mirrored what the founding document itself inscribed. All men are created equal, declared the founders. But they also clarified. The First Nations, they said, were, I quote, merciless savages. Slaves were partial people. Suffrage was reserved for white men. The historian John Hope Franklin's reflection on this embedded discordance in our Constitution stands as a rejoinder to Thomas, Scalia, and Harlan. That great historian put it this way: the promise of real equality made by the Founding Fathers more than 2 centuries ago was a promise they neither kept nor their successors have kept. Now, I might add here that one can question whether there was ever any intent to honor the promise of equality. The promise, rather, was to respect the rule of law, and that is to return to what Harlan described as colorblind, a rule that disarticulates the original racial injustice from the remedy, a rule of law that seeks to hide the gap between formal legal equality and substantive justice. So what we are left with then is a legal regime that prohibits only the most overt and intentional acts of discrimination, leaving intact the vast, enduring historical inequities and the structural systems that sustain them. And this too is why Walker's case is important for us now, because amidst all the talk we hear today about the need to uphold the rule of law, we also have to ask, whose rule of law? Which version of the rule of law are we seeking to keep alive? Now, of course, we all believe in some version of the rule of law, and that we believe as well that it is foundational to how we live together today. It's believed that it's the rule of law that allows us to get on a bus in the middle of the night in Boston without carrying a gun. It's the rule of law that allows us to trust the driver as we cross the street to stop at the red light. It's the rule of law that allows us to practice our faith freely if we do practice a faith. When firms, and we can all agree on this, that when law firms and universities and Wall Street businesses comply in anticipation of a threat, when judges bite their teeth, when the head of the Civil Rights Division of the Justice Department tells us that white people are the victims of racism and that it is her job to, as she put it, quote, turn the train around and drive it in the opposite direction. When our president claims, as he did on Mount Rushmore on July 4th, that, quote, angry mobs are trying to deface our most sacred memorials and unleash a wave of violent crimes in our city. In short, wrapping himself in the mantle of law and order in an attempt to explain away his own lawlessness. When markets prioritize themselves over the common, and when social welfare protections evaporate while the gulf widens between the moneyed class and the rest of us, when they attack our classrooms because they are sources of knowledge that can inspire social transformation, then rightly we should all worry about the much vaunted rule of law. But the Walker case teaches us a different lesson. As we insist on a return to the rule of law, we need as well to examine how a purported rule of law state can also violate fundamental rights. And I submit that the mere return to the rule of law will not be sufficient to get us where we need to be. Let me say a bit more here. Recently in the legal community, there has been much talk of a work published in 1941 Germany by a lawyer by the name of Ernst Frankl. His work is called The Dual State, a contribution to the theory of dictatorship. A Jewish lawyer practicing labor law, Frankl described a regime in which there were two legal systems operating under one roof. One running on the rule of law, the administrative agencies before whom he appeared on behalf of his clients, and the other a lawless and autocratic one. He offered a model for what we see around us today. His dual state theory has drawn an enormous amount of attention, not just from scholars, but in the Supreme Court, where Justice Brown Jackson recently cited Frankl to describe the current rapid erosion of the rule of law in our country. So now how does that apply to the Walker case? Well, Walker was convicted in a regime where autocracy prescribed the law in one community and purported democracy prevailed in the other community. One could also say that the Walker case illuminates what one might call the racial exception to the rule of law. The judge is on the bench, he's robed, the jury receives its instructions, the witnesses are sworn, but the system, and everybody knows this, is lynching by another means. What Walker makes clear is that in the dual state, mere appeal to the rule of law is not enough. And furthermore, let me also say here that appeals to the rule of law simpliciter obscure the democracy deficit that illegitimizes results such as the Walker case. The rule of law requires self-governance, and when a group is categorically excluded from creating the rules that constitute law, as was true in 1950s Dallas, there were no Black doctors practicing in white hospitals. There were no Black elected officials in Dallas until 1969. No judges, no jurors, and very few lawyers. Life in Dallas was up and down, zoned and policed by race. In those circumstances, the rules are themselves unlawful. There is no collective regulation of norms, no common definition of wrongdoing, no accepted understandings of just punishment. And I would add here, parenthetically, that today we face a similar democracy deficit, one that brought us mass incarceration. It's poor Black and Latinx communities, those most affected by the policies that created the carceral norm to which our country is addicted. And those people were nowhere near the decision makers. And so, indeed, the beat goes on. This takes me to my third and final reason why today we take on the Tommy Lee Walker case. We owe the living, Ed Smith, my client, his family, we owe them something, but we also owe the dead something. Indeed, something is owed not just to Tommy Lee Walker, but to the hundreds who stood up for him at that time. They placed themselves in the stream of history. They did so voluntarily. He, not by choice. And they lost that battle, but the war goes on. Their efforts, their letters, their petitions, the protest funeral where thousands lined up, the dollars they threw into the collection plates at the churches that fought for his freedom, all of them deserve the respect that comes from carrying on their fight. And as for Walker, death did not end it. Death brings a close to one's biological existence, but not to one's biography. Aristotle taught that biographies last well beyond our lives. The interests, concerns, and cares that influenced our choices during our lives can be advanced or frustrated after our death. To give perhaps a gross example, our president hopes to mark his territory long after his life is over with, for example, an exceedingly tall building in Miami, a Center for the Arts in Washington, D.C., and maybe, never say no, never say never, a Nobel Peace Prize. He seeks, as do many, posthumous glory. Posthumous punishment also reflects the belief that the corpse can be a vehicle for political expression. Recall, if you will, the lynch mobs that desecrated their victims' bodies, cutting off and distributing fingers and toes, dragging the dead bodies through town, leaving the body hanging on a tree in the middle of town. Recall from a different era that Charles II, on taking the throne in England, had Oliver Cromwell posthumously hung and then beheaded. And hence there is life after death. Some of you may remember the song, "One kind favor I ask of you, please see that my grave is kept clean." Failing to remember those whose deaths were a result of the state's failures enacts a further assault upon them. Bodies brutalized by the legal system illuminate how dishonor and subordination can survive after their death. They evince the never-ending disrespect, the denial that the state assault on them reflected, the assault on them and on their race. Execution is, of course, irrevocable, but the state must, as it has done in this case, as it has done in the cases of wrongful prosecutions of living persons, revoke the wrongful punishment, even if it cannot return to the person, as it would if the victim were alive, control over their lives. And this is, in one sense, the paradox of the irreparable. For in one sense, execution is the penultimate irreparable injury, its irreparability lying both in its incalculability and its irreversibility. But the crisis of the irreparable is that the longer one neglects the demand for justice, the longer one transforms the harm into a permanent, immovable wrong. And now I'm drawing to a conclusion and will share with you some images. So there's much to discuss here. And I've said some things about why we continue to confront and name the violence of the past, why we must face up to the irreparable. One could also ask precisely what it is that Walker and his family are now entitled to. Exactly what does posthumous justice look like, and what precisely is owed to the victims? What forms of reparation make sense in a world of irreparable atrocities? And in a world of too much injustice in our daily lives, the daily lives of our neighbors, what constitutes meaningful repair of events that took place decades ago? And there is also, as well, the question of how, in a world of many injustices, these cases can be mobilized to forge new civic languages and political strategies. Justice claims come in many forms: economic inequalities, historical injustices, intergenerational inequities, institutional injustices, epistemic harms. At the end of the day, what we're talking about is who belongs and who does not. These are all complex questions that I leave for another day, but I would like you to hear the voices of some of those who fought in the Tommy Lee Walker case, and therefore I'd like to turn now to my slides. This is Tommy Lee Walker. He was accused of using a knife to commit the murder. The knife was never located, but this is the press conference a few days after his arrest, in which all the press of Dallas were invited to come in and watch the detectives show off their wares. What they're showing here are knives in their collection that have nothing to do with the crime at hand and nothing to do with Tommy Lee Walker, who was never found with a knife. This next scene is Tommy Lee Walker's sentencing.
Now, do you have anything to say why the sentence of law should not be pronounced against you?
That's the judge.
Will you repeat yourself again, sir?
I say, do you have anything to say why the sentence of law should not be pronounced against you?
Yes.
Well, say it.
I feel that I have been tricked out of my life. There's a lot of other people that have been convicted for crimes that committed it and was turned loose. I haven't did anything, and I'm not being turned loose. That's all.
That's all you have to say.
I'm now turning to the hearing that we had in January in Dallas before the Commissioner's Court. This is Tommy Lee Walker's son, my client, Edward Smith, and his family. The gentleman standing next to Mr. Smith is Mr. Parker. These gentlemen are both in their senior years. Mr. Parker is the son of the woman the woman who was murdered, the murder for which Tommy Lee Walker was framed. And the son has said for years, for decades, that Tommy Lee Walker, he thought, could not have committed the crime. Here they are together before the commissioners. That's the group photo. The commissioner standing behind us.
The Dallas County Commissioners Court does hereby formally recognize and declare that Tommy Lee Walker was wrongfully convicted and executed.
I mean, he knew his father was innocent, but now it's public. That stain has gone away.
And also celebrating in the courtroom
Try not to make the same mistake again.
was Venice's son, Joseph Parker.
This is my new friend. I was talking about you.
Though both lost parents tragically, it's justice that brought them together.
Look, everybody, in spite of what happened to my father, I still love people.
In Dallas, I'm Brittany Moncrief.
These are some shots of the courthouse. And I mentioned the thousands who thronged outside the courthouse to get a seat inside. Here they all are. It's a small courthouse. The hearing in January was held in the same area where Tommy Lee Walker's trial took place in 1954. And these are shots from the Walker case, but I want to share as well some shots from other cases which show the determination, the dedication of those who stood by these folks who were being brought up on false charges. This is a shot from a courtroom in Florida, a similar case. You'll notice that all the folks, that the white folks are all in the front of the courtroom and the black folks in the back. This as well, you'll see that the black folk are all on one side of the courtroom. If you look on the other side, you'll see the white folk. This is North Carolina, 1940. And this case is one from 1948, Georgia. A man by the name of Robert Mallard was killed by a gang of white men in his town. His wife was a kindergarten teacher and beloved member of the community. And she brought his case to national attention and engaged the NAACP in the case. You'll see her sitting behind the books there, and you'll see the gallery where all her relatives are sitting at the top there. Again, completely segregated courtroom. Her name was Amy Mallard, and she traveled across the country to discuss her husband's case. That's her on the witness stand. You think back to that courtroom, all white courtroom, except the top, and her standing there, sitting there, testifying. These are funeral scenes because I mentioned the thousands who appeared at Tommy Lee Walker's funeral. This is from a case in also 1946, Georgia, the Moores Ford case, in which 4 individuals were murdered, lynched at the same time. And this is the funeral of one of them. Same case, 1946, Georgia. This is the funeral of one of the girls killed in Birmingham in 1963. You notice the young pallbearers there and the hundreds of people amassed to bear witness. This too, Birmingham, 1963. Thank you very much.
First of all, I'd like to thank you for a lifetime of the pursuit of justice. Um, and my question is, how has the advent of DNA, I mean, I think you would think obviously this would have a huge impact on the number of incarcerations, but I do wonder if it's changed when maybe there isn't DNA. Has it impacted in certain states, caused a little more reluctance on the part of people knowing that there's all these mistakes that have been found over the years in the prosecution of people where there was some question?
So I point to DNA as providing the opportunity for us to learn more about wrongful convictions. So obviously there were wrongful convictions, have been, as long as human hands are in the justice business, they're going to be wrongful convictions, right? So what you want to do, first of all, which is also an argument why we don't need a death penalty, because death is final, and as I say, there's always the potential for error. Always, whenever it's us who are working the system. So yes, DNA has been transformative, both in our understanding of why wrongful convictions occur, but also in providing opportunities to clear people where DNA is available today before they're put on trial and so on and so forth. So it's critical tool that has transformed the way, but often DNA is not available in every case, and so there's always the potential for a wrongful conviction in cases where DNA is irrelevant or not available, or
Thank you for being here tonight. Earlier you mentioned reformative justice, and I wanted to know your thoughts on reformative justice or even restorative justice, seeing as the convictions that are met out by the justice system seem to be like fundamentally biased or racist.
Restorative, we call our project civil rights and restorative justice. We don't mean restorative justice in the sense of creating opportunities for offenders and survivors to come together to heal the wounds which they have suffered. That's a critically important development in the criminal justice system, really all over the world, starting with two scholars in Australia, and now prevailing in courts all over our country. And it's a critical sort of understanding where the institutional systems fail and where more community-oriented justice practices can help promote healing. So that's critically important. We use the term restorative justice in the sense that the work we do is designed to restore justice that was historically denied to those who faced closed courtrooms, such as the case that I described today. So our challenge is both to identify those cases, but as well to consider what can be done, what, if anything, can be done. So we try to find the avenues where these families who have been waiting for answers for years can get them from official fora like courts, district attorneys' offices, and so on and so forth. So it's in that sense that we use the term restorative justice. Now, we align ourselves with the restorative justice community that works in schools and everywhere else to reconsider how we think about harm and how we reintegrate those who have harmed into our communities in ways that keep us all safe.
Professor, thank you so much. I'm just wondering, I had heard somewhere or read somewhere that maybe at even a minimum 4 or 5% of people who are convicted and who are in prison now are wrongfully convicted, which would mean, probably with 2 million people in prison or jail, probably thousands of people incarcerated now who have been wrongfully convicted. Would you agree with that?
Thanks for adding that. I can attest to that figure, but the numbers grow, exponentially. The more cases we explore, as I said, there's been a huge growth in Innocence Project and Innocence Project-like examinations of these cases. The law firms all across the country are involved. Law schools all across the country are involved in re-examining these old cases. And as I say, there are the district attorney's offices as well, because the district attorney's offices actually hold the files. So you can certainly represent someone who claims they were wrongfully convicted, but unless you have access to the files that the police used and that the district attorneys used, it's really hard to get a conviction overturned. And a lot of times the district attorneys will hold those files back, and you maybe never get access to them. So having district attorneys online with these projects has really been critical. And progressive district attorneys all across the country who see their job as looking at justice in its most broad perspectives are certainly embracing efforts to examine their files and determine whether individuals have been wrongfully convicted. Now, what I will say is, there's two forms of wrongful conviction. In some cases, like the case that I explored with you today, one could say that the wrongful conviction is the person was wrongfully convicted because they did not do the crime. They were innocent of the crime. But it's also the case that one can be wrongfully convicted if convicted outside of the constitutional rules that applied at the time the conviction took place, right? So if you went to trial and you have a lawyer, or you had a lawyer who was asleep in the courtroom, which we've seen in these death penalty cases, or a false confession or whatever, but you don't have enough stuff there to establish that you are in fact innocent of the crime. Those two are wrongful convictions. And so in the Innocence Project, they make a distinction that wrongful convictions that should be overturned. Now, in a lot of our cases, we have a wrongful execution project. We're taking cases like Tommy Lee Walker's all over the country and taking them to both governor's offices. And there is no standard procedure for getting a posthumous pardon, a posthumous exoneration. So, you have to figure out, you have to be creative about this. And so sometimes you go to the governor, sometimes you go to court, sometimes you file what's called a quorum nobis petition. So we're taking these cases up really sort of all over the country, partnering with law firms all over the country that are trying to establish that these constitute a blot on the legal system for all the reasons that I described in my talk, but also, you don't have a justice system if it can't correct its errors. You can't call that a justice system. So it doesn't matter how long ago the error took place. If it's a lethal error, as these cases are, then certainly there's got to be some means of correcting it.
Please join me once more in thanking Professor Burnham.